Welcome to this explainer. We're jumping right into a totally shocking legal paradox today, one that's honestly going to make you question the very laws governing our daily lives and our marriages. We're zeroing in on a massive landmark constitutional court case out of South Africa. This case blew the lid off a severe, deep-rooting flaw in matrimonial property law. We're talking about a legal loophole that literally shielded abusers from financial liability. It is a wild ride, so let's get into it.
Here's our quick roadmap for today. We'll start with the shocking legal loophole itself, then unpack the marriage property trap and break down the different types of damages. After that, we'll run through the constitutional equality test, look at the real-world impact on domestic violence and gender, and finally, see exactly how the courts fixed this broken law.
Section 1. The shocking legal loophole. To really get this, we have to start with a chilling true crime event from South Africa in the late 1990s.
Okay, let's look at the facts of the case. It's October 24, 1999, at a grocery store in Goodwood. A husband intentionally runs over his wife, Vanessa van der Merwe, with his car. And he doesn't just hit her once. He actually reverses over her while she's lying there on the ground. The physical toll was absolutely devastating. She suffered a ruptured bladder, a fractured pelvis, severe contusions, and permanent disfigurement. Just an incredibly horrific situation. Following an event like that, Vanessa naturally sought compensation to cover her massive medical bills. She claimed nearly R500,000 from the Road Accident Fund, or RAF. They're the statutory body in South Africa liable to compensate victims of motor vehicle injuries. But here's the catch. The RAF only has to pay if the victim can lawfully claim against the driver. And that leads us straight into a bizarre legal paradox. Think about it. If your spouse intentionally hits you with a car, who pays your medical bills?
That brings us to Section 2, the marriage property trap. To understand why Vanessa's claim was partially blocked, we really need to unravel the historical context of marriage contracts under common law.
So, in South African law, you can generally be married in one of two ways: in community of property or out of community of property. Imagine a contract where absolutely everything you both own and owe is thrown into one giant shared bucket. That's marriage in community of property. It creates one single, indivisible joint estate. Now, historically, the law barred spouses in this kind of marriage from suing each other. Why? Well, the old logic was that a lawsuit would be totally futile. Any money won would just move out of the joint bucket into the injured spouse's hands and then instantly get dumped right back into that exact same shared bucket. Pointless, right? Section 3. Types of damages explained. Now, in this case, the Road Accident Fund actually admitted liability for part of her claim. And this brings up a crucial legal distinction that essentially split her entire case right down the middle. This split brilliantly illustrates a major clash in the legal system. The law recognizes two distinct types of damages. First, you've got patrimonial damages. These are your standard, out-of-pocket, easily calculable financial losses. Think hospital bills, lost wages, future loss of income capacity. Basically, things with a receipt. Then you have non-patrimonial damages. These are meant to compensate for deeply personal losses that don't have a neat little price tag. We're talking pain, suffering, permanent disfigurement. So in Mrs. van der Merwe's case, the Road Accident Fund told her, hey, we will happily pay you for your pain and suffering, but we are completely denying liability for your massive medical bills and lost wages. No way, they said.
Why would they do that? Well, the exact villain of our story is sitting right here in the phrasing of the Matrimonial Property Act of 1984. The law stated that a spouse married in community of property could recover damages for bodily injuries caused by their partner, but then it explicitly tacked on this phrase, other than damages for patrimonial loss. Because of those incredibly specific words, Mrs. van der Merwe was legally barred from getting a single cent to cover her actual, calculable financial ruin.
Moving to Section 4, the constitutional equality test. As you can imagine, Mrs. van der Merwe did not just accept this. She took the fight all the way to the Constitutional Court. Let's see how this evolved into a rigorous judicial review led by Deputy Chief Justice Moseneke.
Constitutional law can get pretty dense, so to keep things grounded, the judges used a really straightforward three-step equality test. First up, they asked, does this law actually differentiate between categories of people? Well, yeah, absolutely. It was denying a vital financial protection only to spouses who are married in community of property. Okay, step 2. Does this differentiation serve any sort of rational, legitimate government purpose? And finally, step 3, does it amount to unfair discrimination?
When Deputy Chief Justice Moseneke applied this test, he exposed a glaring irrationality in the law.
Remember that old common law excuse we talked about, where the money would just pointlessly cycle back into the shared bucket? Well, it turns out the 1984 Act had already created a loophole for that. The Act decreed that non-patrimonial damages, the pain and suffering money, actually did not fall into the joint estate at all. It automatically became the injured spouse's completely separate property. So the court looked at this and said, wait a minute, if a separate estate concept already exists for injured spouses, there is zero legitimate government purpose to arbitrarily deny them their patrimonial medical expenses. The entire shared bucket argument was completely dead. The restriction was just totally arbitrary.
Section 5. Domestic violence and gender. Now you might be wondering why this dry, highly technical legal phrasing matters so deeply to everyday people in the real world.
To really answer that, the Women's Legal Center Trust stepped in as a friend to the court. They brilliantly zoomed out and laid out the broader societal impact, bringing the horrifying reality of domestic violence right into the courtroom. They highlighted the intense intersectional impacts of this bad law, because physical abuse in marriages is highly gendered, and women are so often economically vulnerable within those marriages. This loophole was actually weaponizing that vulnerability. It was essentially forcing battered women to beg their abusers to use joint funds just to pay the very medical bills the abuser caused in the first place. And even worse, if they couldn't claim from an insurer like the RAF, the crushing financial burden of the abuse fell squarely back onto the victim's shoulders.
Section 6. Fixing the law. Having correctly identified the law as an unconstitutional relic of boundless patriarchy that totally failed the equality test, the court now had to figure out how to fix it.
And the surgical remedy the court used here is just fascinating. They didn't just throw their hands up and strike down the entire act. No, the Constitutional Court literally rewrote the bad law right there. First, they used a legal technique called severance. They legally struck a line directly through those toxic words, other than damages for patrimonial loss. Gone. Then, they used a technique called reading in. They physically added the words, such damages do not fall into the joint estate but become the separate property of the injured spouse. This was a masterstroke. It completely closed the loophole and legally shielded the victim's money from the offending partner for good.
As we wrap up this explainer on what was truly a monumental constitutional victory, it leaves us with a pretty provocative thought. Think about it. This case literally required a woman to be intentionally run over by her husband just to expose a law that had been quietly protecting abusers' wallets for decades. So it really begs the question, how many other invisible, totally outdated common law rules might still be out there, quietly dictating your fate without you even knowing it? Keep questioning, keep learning, and thank you so much for joining me on this explainer today.